Michigan Real Estate Exam Final Review. Question 1. During a license application in Detroit, a salesperson encounters a rule involving the process used when a salesperson changes employing brokers. Which response follows Michigan law? While the file concerns a single-family residence, assigned agency disclosure, and a financing contingency? Option A. Keep both employers until renewal. Option B. Transfer the license through the county register of deeds. Option C. Submit a ME+ modification request for a license transfer. Option D. File a new pre-licensure course application. The correct answer is option C. Submit a ME+ modification request for a license transfer. Employment changes are recorded through the state licensing system. In the described setting, the brokerage should document the step and apply it before moving forward. A deed-recording office has no role in transferring an occupational license. Question 2. A associate broker is preparing for a renewal review in Grand Rapids. Which statement correctly addresses the status that may follow removal by an employer before expiration, while the file concerns a small apartment building, an online advertisement proof, and an unrepresented consumer? Option A. Inactive county registration. Option B. Automatic broker status. Option C. Permanent revocation. Option D. No employer status. The correct answer is option D. No employer status. Michigan does not offer a formal license minus escrow classification for salespersons. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. That status does not authorize independent real estate practice. Question 3. Which Michigan requirement should control when an employing broker deals with the standard salesperson license renewal cycle during a property management meeting, while the file concerns a office condominium, a listing agreement, and a confidential price limit? Option A. 1 year. Option B. 2 years. Option C. 3 years. Option D. 5 years. The correct answer is option C. 3 years. Michigan salesperson credentials operate on a 3-year renewal cycle. For exam purposes, focus on the regulated relationship rather than an informal business custom. The cycle length does not eliminate annual subject requirements within continuing education. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass in payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At an advertising campaign, the brokerage discusses the total continuing education expected within a full 3-year cycle. Which conclusion is most accurate? While the file concerns a condominium unit, a lease application, and a change of employing broker. Option A. At least 18 clock hours. Option B. At least 12 clock hours. Option C. At least 6 clock hours. Option D. At least 40 clock hours. The correct answer is option A. At least 18 clock hours. A full renewal cycle requires 18 hours of eligible professional education. The transaction context changes the facts, but it does not change the underlying licensing duty. Pre-licensure coursework cannot simply be relabeled as renewal credit. Question 5. A compliance question in Muskegon concerns the annual law minus related continuing education component. Which action or statement is appropriate, while the file concerns a retail suite, assigned agency disclosure, and an owner minus licensee conflict? Option A. 1 hour every 3 years. Option B. At least 2 hours involving laws, rules, and court cases. Option C. No annual subject requirement. Option D. 4 hours of appraisal each year. The correct answer is option B. At least 2 hours involving laws, rules, and court cases. Each year of the license cycle includes a real minus estate law component. A written office procedure should produce the same result in comparable transactions. General elective hours do not replace the designated legal instruction. Question 6. How should a Michigan property manager handle a situation involving the annual fair minus housing continuing education component, while the file concerns a manufactured home site, an online advertisement proof, and an expired license issue? Option A. 1 hour of tax preparation. Option B. 3 hours of advertising only. Option C. No fair minus housing instruction after licensure. Option D. At least 1 hour involving fair housing compliance. The correct answer is option D. At least 1 hour involving fair housing compliance. Housing minus equality instruction remains an annual part of professional education. In the described setting, the brokerage should document the step and apply it before moving forward. A general business course does not satisfy this designated subject by itself. Question 7. Which choice best applies the state rule concerning the timing of continuing education in relation to online renewal to a teen training, while the file concerns a 2-unit rental, a listing agreement, and a property-management payment? Option A. Finish the required education before submitting the renewal. Option B. Complete education only if audited. Option C. Renew first and complete education later. Option D. Substitute a new licensing examination. The correct answer is option A. Finish the required education before submitting the renewal. The licensee must be able to truthfully attest to educational compliance during renewal. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. An audit is a verification mechanism rather than the event that creates the obligation. Question 8. A file from Battle Creek raises an issue about the record minus retention period for proof supporting a continuing education certification. Which answer identifies the governing requirement, while the file concerns a historic residence, a lease application, and a delayed possession term? Option A. Permanently with the county clerk. Option B. At least 4 years after the certification date. Option C. 1 year after the course. Option D. Until the license card arrives. The correct answer is option B. At least 4 years after the certification date. Licensees are responsible for keeping acceptable evidence of completed renewal education. For exam purposes, focus on the regulated relationship rather than an informal business custom. Course providers or local offices do not replace the licensee's documentation duty. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a lease negotiation, which rule should the branch manager apply to the consequence of a license being revoked before a new application, while the file concerns a student rental, assigned agency disclosure, and a cooperating brokerage? Option A. Wait 30 days. Option B. Reapply immediately after paying a fee. Option C. Complete only a transfer request. Option D. Wait at least 3 years after service of the final order. The correct answer is option D. Wait at least 3 years after service of the final order. Revocation creates a statutory waiting period before a new license application. The transaction context changes the facts, but it does not change the underlying licensing duty. A routine transfer or fee payment cannot bypass the sanction. Question 10. A Michigan exam candidate reviews a scenario involving the education calculation for relicensure when expiration was less than 3 years ago. Which option reflects the current licensing framework? While the file concerns a vacant commercial parcel, an online advertisement proof, and a rejected counteroffer. Option A. No education is required. Option B. Complete 6 hours for each elapsed year or partial year. Option C. Repeat only the original exam. Option D. Complete 40 hours for every missed month. The correct answer is option B. Complete 6 hours for each elapsed year or partial year. Recent relicensure uses a year minus by minus year continuing education calculation. A written office procedure should produce the same result in comparable transactions. The original salesperson course is not automatically the only route in this situation. Question 11. The broker's policy manual addresses the additional choices after a license has lapsed for 3 years or more. Which provision should it contain, while the file concerns an industrial site, a listing agreement, and an assumed business name? Option A. Pay a late fee only. Option B. Meet the stated relicensure education or examination pathway. Option C. Use an employer transfer without review. Option D. Reactivate through a local association. The correct answer is option B. Meet the stated relicensure education or examination pathway. A long minus expired credential requires more than a routine renewal transaction. In the described setting, the brokerage should document the step and apply it before moving forward. Local membership does not restore state authority to practice. Question 12. A regulator asks about the timing of the Michigan agency disclosure during a brokerage review. Which response demonstrates compliance, while the file concerns a new construction home, a lease application, and a security minus deposit question? Option A. Whenever the licensee chooses. Option B. After the first offer is rejected. Option C. Before the prospect reveals transaction minus specific confidential information. Option D. Only after closing. The correct answer is option C. before the prospect reveals transaction minus specific confidential information. Available agency relationships and their duties must be explained early in the interaction. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A closing minus stage disclosure would come too late to protect informed choice. Question 13. Which statement would be safest for employing broker to follow when the form of the required agency relationship disclosure becomes relevant, while the file concerns a mixed minus use building, assigned agency disclosure, and a dual minus representation concern? Option A. A written disclosure. Option B. A note prepared after settlement. Option C. A social minus media post. Option D. An oral statement only. The correct answer is option A. A written disclosure. Michigan requires documentation of the agency information given to a prospective buyer or seller. For exam purposes, focus on the regulated relationship rather than an informal business custom. Informal conversation alone does not satisfy the statutory format. Question 14. A dispute arises during an open house over acting for more than one party in a transaction without their knowledge. Which principle resolves the issue, while the file concerns a cooperative unit, an online advertisement proof, and a protected minus class inquiry? Option A. Required in every transaction. Option B. Permitted whenever commission is shared. Option C. Prohibited conduct subject to discipline. Option D. Allowed if the property is residential. The correct answer is option C. Prohibited conduct subject to discipline. A licensee cannot secretly undertake conflicting representation. The transaction context changes the facts, but it does not change the underlying licensing duty. Compensation structure or property type does not eliminate the conflict. Question 15. In Holland, a listing licensee must decide how to proceed with a salesperson attempting to represent a broker other than the employing broker. Which decision is consistent with Michigan requirements, while the file concerns a farm parcel, a listing agreement, and a disputed repair credit? Option A. The salesperson may do so without notice. Option B. Only the buyer must approve. Option C. The employer's express knowledge and consent are required. Option D. A title company may authorize it. The correct answer is option C. The employer's express knowledge and consent are required. A salesperson's regulated activity is controlled through the employing brokerage. A written office procedure should produce the same result in comparable transactions. A transaction participant cannot substitute for the broker's supervisory authority. Question 16. Which exam answer accurately classifies the rule involving the meaning of a seller's agent, while the file concerns a lakefront cottage, a lease application, and an electronic signature? Option A. A licensee representing the seller with fiduciary responsibilities. Option B. A neutral county official. Option C. A lender's underwriting employee. Option D. A person representing only the buyer. The correct answer is option A. A licensee representing the seller with fiduciary responsibilities. Seller representation places the licensee on the owner's side of the agency relationship. In the described setting, the brokerage should document the step and apply it before moving forward. The role is different from neutral coordination or buyer advocacy. Question 17. A new policy is being drafted for the meaning of a buyer's agent. Which language belongs in the policy, while the file concerns a townhouse, assigned agency disclosure, and a referral arrangement? Option A. The listing broker in every case. Option B. The closing notary. Option C. A licensee representing the purchaser's interests. Option D. The seller's property inspector. The correct answer is option C. A licensee representing the purchaser's interests. Buyer representation is established to advocate for the purchaser in the transaction. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Performing a ministerial closing task does not create this relationship. Question 18. During team training, the supervising broker tests knowledge of the purpose of informed consent in dual representation. Which answer should the team select, while the file concerns a urban infill property, an online advertisement proof, and a team social minus media post? Option A will allow the parties to knowingly approve the conflict minus managed relationship. Option B to eliminate every disclosure duty. Option C, guarantee a specific sale price. Option D, let the salesperson work for two brokers. The correct answer is option A, allow the parties to knowingly approve the conflict minus managed relationship. Dual representation involves duties that may compete between opposing clients. For exam purposes, focus on the regulated relationship rather than an informal business custom. Consent does not promise an outcome or erase mandatory honesty. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain the role of designated agency within a brokerage. Which explanation reflects Michigan law, while the file concerns a subdivision lot, a listing agreement, and a record inspection request? Option A. The parties become unrepresented automatically. Option B. One licensee secretly represents both sides. Option C. The broker stops supervising the transaction. Option D. Different affiliated licensees represent opposing clients under brokerage safeguards. The correct answer is option D. Different affiliated licensees represent opposing clients under brokerage safeguards. Designation can separate client representation among affiliated licensees. The transaction context changes the facts, but it does not change the underlying licensing duty. The structure is not a license for undisclosed dual loyalty. Question 20. Which compliance step is required when the transaction facts involve the role of a transaction coordinator, while the file concerns a rural acreage, a lease application, and a branch-office distance issue? Option A. A universal agent for both parties. Option B. The owner of the listing. Option C. The county equalization officer. Option D. A licensee who is not acting as agent for either buyer or seller. The correct answer is option D. A licensee who is not acting as agent for either buyer or seller. A coordination role may facilitate documents and communications without client advocacy. A written office procedure should produce the same result in comparable transactions. Administrative support does not create unlimited authority over either party. Question 21. A salesperson notices a potential problem involving the effect of compensation on determining agency. Which response should occur first? While the file concerns a single-family residence, assigned agency disclosure, and a financing contingency? Option A. Payment alone does not decide whom the licensee represents. Option B. Commission creates dual agency automatically. Option C. Only cash compensation creates agency. Option D. The payer is always the client. The correct answer is option A. Payment alone does not decide whom the licensee represents. Agency depends on the relationship and disclosures rather than the source of money alone. In the described setting, the brokerage should document the step and apply it before moving forward. The form of compensation does not replace the need to identify the actual principal. Question 22. The state portion of the exam presents facts about the agreement that defines brokerage services for a client. Which result is supported, while the file concerns a small apartment building, an online advertisement proof, and an unrepresented consumer? Option A. A verbal promise from a customer. Option B. A written service provision agreement. Option C. A tax assessment notice. Option D. An unsigned advertising draft. The correct answer is option B. A written service provision agreement. Michigan brokerage services are organized through an agreement identifying the relationship and services. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A public advertisement or assessment record is not a substitute for the brokerage contract. Question 23. Which brokerage practice properly addresses the function of a limited service agreement in the Battle Creek transaction, while the file concerns an office condominium, a listing agreement, and a confidential price limit? Option A. Transfer the broker's license to the client. Option B. Remove every duty of honesty. Option C. Authorize unlicensed practice. Option D. Permit specified services to be knowingly waived in writing. The correct answer is option D. Permit specified services to be knowingly waived in writing. A limited service arrangement narrows selected brokerage services through a documented waiver. For exam purposes, focus on the regulated relationship rather than an informal business custom. Core legal obligations and licensing requirements are not erased by the reduced scope. Question 24. A licensee is comparing four procedures related to the purpose of a property management employment contract. Which procedure is lawful, while the file concerns a condominium unit, a lease application, and a change of employing broker? Option A. Transfer title to the property manager. Option B. Define the broker's management duties and handling of property funds. Option C. Replace all lease agreements. Option D. Create a mortgage lien. The correct answer is option B. Define the broker's management duties and handling of property funds. Property management for another is based on a written employment arrangement. The transaction context changes the facts, but it does not change the underlying licensing duty. It does not convey ownership or eliminate contracts with tenants. Question 25. At the end of a seller consultation, the parties question the source from which a salesperson may accept brokerage compensation. Which statement provides the best guidance, while the file concerns a retail suite, assigned agency disclosure, and an owner-licensee conflict? Option A. The employing real estate broker. Option B. A home inspector. Option C. A buyer directly without broker involvement. Option D. Any cooperating salesperson. The correct answer is option A. The employing real estate broker. Salesperson earnings for regulated activity flow through the employing brokerage. A written office procedure should produce the same result in comparable transactions. A transaction participant cannot bypass the broker by paying the salesperson directly.